Ladies and gentlemen, this last panel of the day is entitled Enforcers Roundtable, What's Under the Radar? I think it's interesting because during most of the day we've heard quite a few things about where antitrust shouldn't go. So it's useful that before we get to the cocktail, we get some impression of where it is going. And we have 4 enforcers with us today. They are going to talk about a variety of issues. Some of them are on the procedural side. Some of them are thinking about what the substantive analysis should be in the future. Some of them will deal with cooperation initiatives, and some of them will deal with challenges that they have experimented. So I think it's very interesting to know what is in the mind of the enforcers, and I'm very glad to be so well surrounded by enforcers. Now, without really making presentation, but I will mention that Roger Alford is the Deputy Assistant Attorney General of the U.S. DOJ. We have 2 U.S.'s with us because Randy Twitel from the FTC is also going to make a presentation. Tembi has been here all day, and we've already seen him. And Joseph Wilson, who is to my right, comes from Pakistan and will talk to us about the state of competition and competition law enforcement in Pakistan. I think we should start. I'm going to give the floor first to Roger Alford. One of the things which has been very noticeable is that Megan Delrahim and the Justice Department has talked quite a bit recently about how to promote greater procedural norms and due process throughout the world. So we would be interested in hearing more about this initiative, how it came about, where it's going, and how far it is along. So, Roger.
Thanks, Fred, very much. And thank you for the chance to be here, to speak to you again. I was here last year, and Megan Delrahim's first speech as AAG was here. I gave a big push for my alma mater for him to be his first big speech to be here at NYU. And if you read that speech, he clearly hinted at where he was headed, even though it was all covert at the time, in talking about how we need to do some new, fresh, creative thinking about how we can effectively promote due process around the world. So we have been working for months behind the scenes, literally from the very beginning that Megan arrived at the DOJ in September, and then reaching out to our colleagues around the world, literally also for months and months. And the goal of this initiative is to essentially try to promote fundamental due process in competition enforcement, both in the investigation stage and in the enforcement stage, to try to improve more effective cooperation with antitrust authorities around the world. We believe that basic minimal due process protections are of fundamental importance in antitrust enforcement, and our partners around the world agree with this sentiment in essence that procedural fairness is a prerequisite to legitimacy of antitrust enforcement. So really the idea is, what is the idea? You have to respect the fact that there's going to be diversity on the margins with competition enforcement, right? But what you also can agree, and I think agencies do agree, is that there can be uniformity at the core. And so what we're really trying to focus on is what sort of procedural norms would one say are really core procedural norms that everyone can agree about, regardless of whether or not it's a civil law country or a common law country, regardless of whether or not you have administrative process or prosecutorial process, regardless of whether or not you're a young agency or an older agency, a mature, strong economy or a fledgling economy. All of those, I think, it's possible in all those contexts to have core due process norms. So that's really the focus of what we have been doing. This is not, in many respects, this is not a new initiative. The idea of due process, Fred and I were talking last night, due process has been a major initiative for at least 10 years. Christine Varney, the first AG under Obama administration, gave a big push for it in 2009. Thus far, it has primarily been manifest in two contexts. In the context of OECD and ICN recommendations and guiding principles, and then also in competition chapters in various free trade agreements. Those are the two contexts where it's been most visible. So we were thinking that, is it possible that one could go, sort of complement and go further from those basic experiences by thinking about taking the model of bilateral cooperation agreements, which are, there's over 150 of those around the world, and then rather than having a traditional cooperation agreement, which is essentially sort of a statement of amity, you know, of friendship, to actually have, you know, the ideas that would be in ICN principles, ICN recommendations, FTA competition treaties. So the idea was to take the combination of ICN recommendations, OECD initiatives, free trade agreements, and cooperation agreements, and put them all together into a new package that would be a multilateral framework on procedure. And again, the goal would not to be aspirational, but to simply reflect what are the core norms that all the major agencies are doing. And then the hope is that with 130, 140 different competition authorities, that there would be a common set of agreement about what every single entity that appears before every agency in the world could expect, right? That's the basic idea of it. So what are the kind of core principles that we're talking about? Things like non-discrimination, transparency, meaningful engagement, timely resolution, confidentiality protections, avoidance of conflicts of interest, proper notice, opportunity to defend oneself, access to counsel, and independent review of enforcement decisions. Those are the kinds of things that we're focusing on. And we're happy to say that it's not been controversial in respect to identifying what are the core norms. There has been a huge amount of support for the identification of those norms and the articulation of those norms, and to try to articulate in a way that is truly universal. For example, you can't say that something that is unique to the common law tradition is a universal norm, right? So much as many practitioners would like to say we must have cross-examination, if cross-examination is not in civil law traditions, then you can't say we must have that in a declaration of uniform norms, right? You can pursue other things that are close to that, but you can't pursue that per se if it's strictly a common law norm, right? So we truly are trying to promote universal norms. The other difference with the multilateral framework is, unlike anything else that we've seen at the ICN, at the OECD, we really are trying to promote meaningful review mechanisms. The review mechanisms essentially mean that it's one thing to have these statements of what are uniform norms. It's another thing to say that we'll have periodic review of the implementation and assessment of the progress with respect to those norms. So the multilateral framework has designed, embedded into the multilateral framework are review mechanisms. This is extremely common in many, many other areas of international law. I've canvassed, I can't tell you how many treaties and other sorts of agreements, MOUs, and there are review assessments, implementation bodies, periodic reports that happen in almost every other area of the law. So it's extremely common to do that. And so the kinds of things we're looking at in terms of review mechanisms are, you know, the kinds of things such as bilateral dialogue and consultations, self-reporting of how one is in compliance with the core norms, periodic review by the various participants. Those are the kinds of things that we're looking at with respect to review mechanisms. Nothing that would go as far as anything in it binding in any serious way. There would be no arbitration or tribunal or anything like that. But nonetheless, meaningful review mechanisms, I think, are possible. The other thing that's unusual about the MFP is that it is a statement of commitment. It is a promise to do something. And if you look at the literature on international law about why nations comply with international law, They primarily do it for three reasons. Fear of retaliation, hope of reciprocity, and the desire to promote one's reputation. Right? That's the classic literature on why nations obey international law. There's other reasons, but those are the three most common. In this situation, we're talking about if you make a promise that you're going to not discriminate, or you're going to provide access to counsel, or you're not going to have conflicts of interest, and then you breach that promise, there is a greater consequence to that breach than simply not following a recommendation that an international organization submitted to you. And so the hope is that the promise to abide by a norm will increase the likelihood of adherence to that norm. And so we're simply implementing in the antitrust context a norm that is extraordinarily common in other contexts as well. So that's the basic background of the multilateral framework. It's been extraordinarily well received around the world. We have been on the phone nonstop for the past 6 months, emailing, calling, talking, visiting, traveling, and trying to basically do bilateral discussions and then the occasional also group discussions with interested parties. We started with a core group of competition authorities. We thought it would be appropriate to identify leading common law and civil law traditions and see if we could get to come together with a common text. That common text was shared with every competition authority in the world in August, and then every competition authority that was interested in September came and met in New York to discuss, and we had over 36 different competition authorities join us for those discussions. And so the current status essentially is that we are taking the suggestions, the concerns, the ideas of every competition authority in the world right now, and then trying to think about ways that we can sort of implement those ideas. And the focus overwhelmingly has been on the review mechanism, which speaks to the fact that we, I think, did a good job in articulating the sort of fundamental norms. And so most of our focus for the past few weeks has been trying to get consensus with respect to the review mechanisms, how you articulate them, and how you commit to them, because that's the one thing that everyone knows is new, right? That's a new thing on the horizon. So that's sort of where we are with respect to the negotiations. The next steps are we will be meeting on the margins of OECD at the end of November with, yet again, a very large group of negotiating parties to try to work through the next draft of the text. And then I think we'll see where we are at that point. So that's sort of where we are in terms of it. If I can, just in one final comment, there have been some concerns expressed, and in fact, Commissioner Vester expressed this at Georgetown last month, about why are we not doing this within ICN? Why can't we do this through international organizations? And obviously, we're very sensitive to that. We think this is completely complementary to everything that we've been doing at ICN with respect to recommended practices. It's certainly consistent with everything we've been trying to do at OECD as well. But there's essentially a few core ideas. One, we've talked to Fred about this many times, but the OECD only has 36 members and a few observers, and you try to have an agreement that is available for every competition authority in the world, and the OECD is not necessarily the right institution for that sort of attempt. Likewise, with the ICN, many competition authorities are members of ICN, but not everyone, including some major ones that one would like to be. So there's a question about membership also with respect to ICN. ICN also has an issue with respect to culture. The culture of ICN is very much sort of collaborative and collegial, and they've never had anything remotely like review mechanisms or implementation tools that have been built into it. It's always been a source of incredibly helpful discussions and recommendations, but it's not had a culture of trying to promote compliance through any sort of review mechanism or the like. And then the final concern is that the consensus voting mechanism of ICN means that even one leading competition authority that wants to prevent major progress in the ICN context is able to do so. And so you run the risk of a least common denominator document if even one competition authority is hesitant about the progress that one would want to do within ICN. And so the idea of the MFP is that you can find ways to incorporate a role for ICN, but you don't need to run the risk that there may be one or two agencies that are not as enthusiastic. And so essentially what that means is it's an opt-in model, right, rather than a consensus model. And so any competition authority in the world that is interested in joining the initiative is more than welcome to do so, even though that may mean that there may be a few agencies that are not interested at this time for whatever reason. So I'll stop there.
Thank you very much for this very clear statement of an opt-in model rather than a consensus model. There is still a little, you have not gone into much detail on how the work which is being done at the ICN, the work which is being done in the OECD, and the work that you try to do, really how they complement each other. And the question which is often asked is whether there's duplication in there and whether we have the same people doing the same thing in different contexts, because each one has a slightly different view of the other. The second one is, it seemed, but I may have misunderstood what you said, is that rather than having a collaborative mechanism to in fact arrive at an idea on what could be something that would presumably be positively seen by a large number of countries, you gather ideas and then you are going to try to synthesize them. Now, how is that process better or more effective than a more collaborative system?
So on the first question, I mean, we have always thought and always openly said that this is complementary to everything that has happened at the ICN and OECD context. In fact, one would simply, I think, argue quite credibly that this is the next iteration, the next logical step in the process that has happened thus far. We've only been really trying to do due process initiatives within the ICN and OECD for less than 10 years, and in the first few years of those, it was met with very strong resistance. And so we're really talking about a very small window of time that there's been a lot of work done on due process and procedural fairness within those organizations. And the progress that has happened there is really noteworthy and significant, but I think one could very safely say that what it doesn't include are the things that I mentioned. So let me put it this way. The norms that are articulated at ICN and OECD were used as a component for the input of what went into the MFP, along with other similar initiatives, to try to reflect what was in fact the universal norms, right? So the norms are in there, but then the combination of that is that you could actually reflect a strong version of those norms rather than a weaker version of those norms because there wasn't consensus voting. So that's the way I think I would answer the first question. On the second question, it absolutely is collaborative. The entire initiative is collaborative. We started with a core group of about a dozen competition authorities, got one draft of the document, and then opened it up to every competition authority in the world. And if you don't think it's collaborative, you should see my Excel spreadsheet of all of our communications with 80 different competition authorities around the world. So we are literally engaging in phone calls every single week with some competition authority about this initiative and trying to get their input and discussion with them. And so it's done both at the multilateral level through meetings on the margins of various conferences and events, but also done through, and this is not just the United States, many other countries that are promoting this are doing the same exact thing. This is a very much a group effort. Brazil, for example, is talking to everyone in South America, as well as all of the BRICS countries about this initiative. And so this is the kind of thing that I think it is collaborative. If we were to go too fast and just sort of force this initiative on a larger group, then one could be accused of not being collaborative. But the fact that we're going in different stages, I think it's hard to say that it's not collaborative. It is, as you say, though, not subject to a consensus-based voting procedure, which some people would prefer that it was.
Okay, it will be interesting in any case because, as you know, the OECD is, as one of its strategic themes, developing principles of procedural fairness and due process. So, I mean, two initiatives.
And we chair that initiative.
That's right. That's right. Which, okay. Has anybody got any comment on this? No? Tembi. Tembi is about to have a slightly difficult time. You had a good time all day, so now is the time. South Africa just changed its competition law, and I was preparing for this debate. I just went on the internet and looked at some of the commentaries that I found. Okay, there's a new law which will give significant interventionist powers to the Minister for Economic Development. New law which will change the burden, no, which will lower the burden of proof for the Competition Commission, or even reverse it. That's intriguing. And the conclusions of some of the commentaries with doing business in South Africa is going to be possibly more difficult than it was. Now, I'm not sure that you agree with all this, but it would be good if you started by telling us, if you want another comment, serious departure from commonly accepted best practices in the international world of antitrust law. Okay. So maybe you can talk to us about what those changes are, what they say, what you think of them. Were you on the demand side, or it was something that, an initiative that came from elsewhere, and how you assess those comments that I've just mentioned.
Thank you. Maybe let me explain the law, and everybody can draw their own conclusion.
Yeah.
So, I mean, this is pretty much a regular review of the law. It's in fact 20 years now since the promulgation of the current legislation. The institutions have been working fairly well, I think. But there are also gaps that have been identified. One of the major gaps, or frustration, I should say, are these issues around concentration and the seemingly inability of the current legal regime to deal with abuse emanating from this. So if you look at the track record of the competition authorities, done very well against cartels, things like that, but where you have unilateral conduct, which is a conduct emanating from the fact that the economy is concentrated. I think there is a considerable debate in South Africa about what do you do, on those matters that relate to the structure, really, of the economy. And so one of the amendments is the introduction of a possibility to have binding remedies after a market inquiry. So like in so many other jurisdictions, currently the market inquiry can only make recommendation, non-binding recommendation, persuasive but non-binding. And so that's the first change. And the ultimate recommendation that can be made is to break up a firm. That would be the recommendation that will be subject to review by the tribunal. In fact, we can't impose it. We must recommend it to the competition tribunal and ultimately subject to judicial oversight. So that's the first so-called controversial change. In fact, this is almost copied verbatim from the UK law. The second issue that emanates from the bill is the regulation of monopsony power, which we didn't have it before, and now it is expressly provided, and is particularly about ensuring participation of small and medium enterprises as well as enterprises owned by historically disadvantaged persons. So that's another sort of lot. And then what was probably unexpected is that in the competition legislation, there was this national security provision. This was kind of a late addition to these amendments, and there was some debate about whether to have this in the competition statute or to have a separate statute dealing with it. But in the end, it was put there, and essentially provides for the establishment of a committee which will be, I think, chaired by the president, or at least his nominee, which may have veto over transactions where foreign acquiring firms acquire security-sensitive firms from South Africa. So I would think that those are the main. There are some changes that do help to clarify a little bit. So excessive pricing, there's some changes, but nothing major really. And predatory pricing, making it consistent actually with the rest of the world rather than being out of the norm. So probably out of the norm, I don't know what would be out of the norm here. National security, maybe. Market inquiry, yes, because we now join only the UK actually that I know of that can break up firms. But that is the installment. We can then talk about what the implications of this are. There is an issue that has been raised in some quarters about the role of the minister. So with respect to mergers, the minister has always had a role to play in terms of intervening when there are public interest issues. And the Act actually doesn't change this. The second area where the minister is involved currently is he can direct the competition authorities to initiate a market inquiry. So that's new. Previously, he could request a market inquiry. Now he can direct the initiation of a market inquiry. That did worry me a little bit. Actually, I was more worried about the resource implications of that because ministers, we manage the resources of the agency, and it's kind of hard to see how the minister can determine, your work plan. It's also possible that you could have abuse of this if you had a minister maybe who had an axe to grind against a particular sector or industry. So I think that overall it's strengthening some aspects of competition enforcement in a way that I like. In some ways, I also think that it contains some unnecessary provisions. So that's my take on it.
Thank you very much. When you say that there's a new provision to deal with monopsony power, what does the provision say? Is it a new provision that deals with buying power in general or with monopsony power in the narrow economic theory sense?
It's buying power.
It's buying power.
It's buying power,
Okay,
yes.
okay. And it creates an abuse of buying power. Okay. Second, in the abuse of dominance, I've read somewhere that you have you've introduced a reasonableness criteria on excessive prices. How does that work?
Yeah, excessive pricing has always been controversial in South Africa. Those familiar with the European sort of test, the United Brands test of a price that's that's not related to the value of the goods or products. So we've grappled this. We've even fought amongst ourselves with the judges and the tribunal at different times. But I think the consensus was that the test that was in the law was the one leading us to these problems. And so we've moved away from United Brands. We've simply removed the definition that was in the legislation. And we have instead replaced it with what you call the reasonableness test. In fact, what we have is a list of things that the court could consider in order to determine that a price is excessive. So, for example, prevailing prices in similar markets or prevailing prices in markets where there is competition, prices for similar products. So what the legislation has done is to give a menu of options to the adjudicator to factor in when considering whether a price is excessive or not. I think that it helps us to start. It helps us to move away from the previous kind of jurisprudence that has hamstrung us. So it's not going to make excessive pricing easy. It's never going to be an easy area of the law. But I think that the law now is broad enough to allow everybody involved to be more creative about solving the problems, in that we're not prescriptive on really what you should consider. We have some examples of what you could consider, but when you see the problem, you now have an opportunity that you can solve it. So I don't think it's too bad. I think it's actually more helpful, not just for authorities, but for the parties as well, because the list is there, although it's not exhaustive.
Final question, did I read that there is a provision that's going to make exemptions from competition law easier?
There is
Is it on a case-by-case basis, or is it at the ministerial level? In other words, how does this work?
Yeah, we currently have a provision where you could get exemptions in South Africa, and the grounds for exemptions are very narrow and exhaustive. So we got a lot of extensive lobby by business arguing for an EU-type block exemption, which we didn't like, arguing that this may be good for things like joint ventures and for growth more generally. And I think government was sympathetic to that. And so we ended up with a much broader, with a catch-all provision for exemptions. Again, very similar to the EU in many ways. So when you look at this in detail, after we've made all the submissions, there is nothing here that's really completely original. I mean, it's kind of a mixed bag of some of the radical thoughts that exist somewhere in the world, like breaking up firms, and some of the more clearer sort of, and a way of clarifying certain provisions. That's not what worries me about this law. I think the thing that worries me as an enforcer is the scale of the ambition in the law, in a sense that is its strength and its weakness. There are so many ideas in this law that I'm worried about whether it's able to live up to this ambition. There's so many things that are going to require guidelines and bylaws by the minister and by ourselves, which doesn't excite me. So I think that that's a product actually of how we do laws, because there's a lot of there's a lot of stakeholder participation in South Africa. So there are a lot of ideas here that came from business, some ideas that came from labor, and some ideas that came from us and government. In the end, what you end up with is many of these ideas making it into legislation as a compromise. And in a sense, you have to work with that text, which is a compromise, rather than giving you the best option available.
Okay, well, thank you very much. This was highly interesting. So, I mean, my take is that overall you're not dissatisfied, and you certainly don't agree with some of the comments I've read. The only place where you don't see yet how it's going to work out is the possibility for the minister to force you to start a market investigation, which is a power it didn't have before. And that's where you're a little concerned about the independence, so to speak, of the competition authority.
Yes, that's right. I mean, I think, as I said, there's nothing really new or radically different here that should worry any investor. What there is in South Africa and elsewhere in the world is this problem of national security, which we never debate, of course, in an antitrust conference. But it's a real problem because it's really growing. You know, a lot of countries are adopting it. And eventually, I think most countries are going to do it because it can be used as a protectionist mechanism. So as an antitrust practitioner, of course, I do worry about that, about the extent to which this can be abused. But I also know that it's not a South African problem.
Okay, I admire you for saying here in the U.S. that national security can be used as a protectionist device in the world. It happens in many countries, indeed. But okay, thank you very much for this. Are there any questions on the South African law that anybody wants to raise? If not, I'm going to welcome Randy. The FTC is back. Some of us were wondering where the FTC was. I mean, there were fewer and fewer members of the FTC. But the FTC is back with a big bang, because not only is there a new commission, but there is also hearings which have caught the imagination of the whole world. So you're going to have to tell us what is the new life at the FTC.
Thank you. I will try to do that. So thank you, Fred. And I want to thank Professor Fox, Professor First, Nicolas, for bringing me back to this conference. It's always a delight to be here. In the differentiated market for competition conferences, this has a unique niche in its focus on issues affecting the developing countries. And it's an important one that this conference fulfills so well. And I'm very lucky to be back here with a terrific group of friends and colleagues on the panel today. And thank all of you for sticking through it for the day and being here with us at the end of the day. And let me just add that any views I express are my own and not necessarily those of the Federal Trade Commission or any of our commissioners. Fred, I have to correct the record a bit because the FTC never went away. Although the number of our commissioners had decreased, we had an extremely, yes, right, but that was not to the detriment of our effectiveness or enforcement, and I think the record speaks for itself. We had a very productive year under the acting chairmanship of Maureen Olhausen with her colleague Terrell McSweeney. But we are glad to have a full complement of commissioners now with us. So as of a few weeks ago when Christine Wilson joined us, we do indeed have fully staffed 5 commissioners, all who have taken office in the recent period. It's not what was envisioned. We have a system of 7-year staggered terms. So there should be 5 commissioners taking office over 7 years, not over a few months. But we have a very talented group who are very familiar with what we do, and we are up and running from day one. And I'm very glad to say that, having spent some time with all of them now, they are uniformly, strongly committed to the FTC's international agenda, which they recognize as critical to fulfilling our competition mission as well as our consumer protection and increasingly important data privacy missions. I'm going to talk some about the series of hearings that Chairman Simons has launched, but I'm just going to spend a couple of minutes with some general updates about where the FTC is and is going, and a bit about our international antitrust program. And we have, I think, a record amount of litigation in the antitrust area right now, and it spans the gamut of our mandate. We've had a very active merger enforcement program driven by, we're up to around 2,000 notifications a year to the agencies. And we've had a variety of cases across industries involving horizontal mergers, also challenged a vertical merger, and we've been refining our merger review procedures to make them more user-friendly while still effective. We're still very active in the healthcare field, which our enforcement has included a case with a $1.2 billion settlement in a reverse payment case. And we've brought unilateral conduct cases in that sector on theories of sham litigation and repetitive regulatory filings to harm a competing drug product. We have a case involving labor markets, which were discussed today, where we challenged a conspiracy to suppress compensation provided to therapists to home health agencies. And our Competition Bureau Director, Bruce Hoffman, put out a very strong and clear statement saying that the FTC will enforce the antitrust laws against any companies that agree not to compete for workers or attempt to drive down workers' wages. And we're, of course, paying a lot of attention to the digital sector that we've been discussing so much today. In terms of our international antitrust program, we're fully engaged with colleagues around the world. We met very recently with Commissioner Vestager and her team in Washington. I, along with Chairman Simons, Russ Damtoft, who's here, and others, and our colleagues at the Antitrust Division are going down to Mexico to have our annual consultations with the Mexican and Canadian agencies. And we expect to have consultations with agencies in China and in Japan early next year. We are in a constant process of collaborating on cases under mutual review. A good example is the EssilorLuxottica matter that was settled by the FTC just a few days ago, in which we collaborated with 10 agencies around the world on the analysis and on remedies, all leading to consistent outcomes. I'm going to turn to the multilateral work we do and start with the International Competition Network, which this very day is celebrating its 17th birthday, created here in New York in 2001 by a handful of agencies, and now with over 130 agencies that truly span the globe. The FTC has always played a leading role in the ICN. That continues. One of our signature projects is on the same topic that Roger was addressing on procedural fairness. And we are currently in the process of elevating the standards that were developed, addressing issues like transparency, procedural fairness, into recommended practices, the highest form of norms and benchmarks in the ICN. The FTC also co-leads the ICN's implementation work, where we very importantly take these nice documents and try to help agencies incorporate those into the DNA of their daily work. The FTC co-chairs the ICN's merger working group. One of our main projects is on the very topical area of vertical mergers, and our new Commissioner Wilson is going to lead an FTC delegation to an ICN workshop on mergers in Tokyo in a few weeks. We also have a group going down to South Africa to a workshop that the South African Competition Commission is chairing, and that'll include my colleague Cynthia Lagdameo, who is here, and we have an upcoming workshop on competition advocacy. We also have an important project, especially for young agencies, called ICN Training on Demand, that is run by Russ Damtoft, in which Eleanor Fox is very heavily involved, and other colleagues here, that has produced and is continuing to produce a comprehensive curriculum of training materials on video available free of charge to anyone, but again, particularly to help new staff, and in younger agencies. We're involved in competition aspects of trade agreements, having helped negotiate the competition chapter of the new U.S. Mexico-Canada agreement, the revised NAFTA, and you may have heard some talk about possible new trade agreements, and if those have competition chapters, we'll be part of those efforts. We have a very robust worldwide technical assistance program. We've stationed long-term advisors in the agencies in the Ukraine and in the Philippines. And we just had a group come back from the Philippines to train judges that'll hear antitrust cases. Same goes for India, where we've had a long-standing program for the CCI, and we hope to be training judges there as well. Just today, my colleague Molly Askin got on a plane to Eswatini. I thought I was pretty good at geography, but I had to look that up and found out that it's in Swaziland, where Molly will be working with a group of African competition agencies. And we hope to be in Pakistan in January with Joe's former colleagues. So we're quite busy and active across the board. And now I want to turn to a signature initiative of Chairman Simon's, which are a set of hearings meant to address the very issues that we were debating and discussing all day today. Issues about concentration and platforms and the relationship between antitrust and inequality and data privacy and so on. And our chairman in launching them said the FTC is committed to understanding how technological developments and globalization can and should impact our law enforcement, research, and advocacy. So drawing on the FTC's authority and tradition of using our research function to inform our priorities and enforcement, the chairman launched a wide-ranging series of hearings entitled Hearings on Competition and Consumer Protection in the 21st Century. And they're going to consider whether broad-based changes in the economy, evolving business practices, new technologies, and international developments warrant adjustments to our competition and consumer protection law priorities and policies. These are modeled on an initiative in 1995 led by the late former Chairman Bob Pitofsky. The Pitofsky hearings in 1995 re-energized the FTC's research functions to gather leaders from the consumer, legal, business, and economic communities for critical discussions and analysis of the trajectory of antitrust enforcement. And that was the first step in creating and establishing the FTC as a key modern center for what Bill Kavasik calls competition R&D. That led to a well-received report anticipating the 21st century, which presented analyses and recommendations on competition and consumer protection policy. And this is the first comprehensive set of hearings since then to take on how recent changes in the economy, big data, digital economy, mobile economy, broadband, as well as important new research and landmark court decisions have influenced the landscape. And these hearings are led by our Office of Policy Planning under Bilal Said. And Bilal is also trying to align the priorities of that office with the Commission's enforcement agenda. The hearings kicked off last month at Georgetown University Law Center with opening sessions on market concentration and competitiveness, enforcement policy, and the regulation of consumer data. We had a second hearing on the state of U.S. antitrust law and on mergers and monopsony. The third hearing recently was on platform issues and included a session dedicated to US-EU comparative approaches, and also had a session on the antitrust evaluation of labor markets. Just this week, we devoted 2 days to a hearing on innovation and intellectual property. And next Thursday, we'll be holding hearings on vertical mergers and the consumer welfare standard. Later in November, we're going to be taking on algorithms, AI, and predictive analysis. And we'll soon be announcing a new hearing date on privacy, big data, and competition. All of these hearings feature a wide and diverse range of speakers from every part of the spectrum. We've also invited written comments, and happily, stakeholders have taken that up enthusiastically, and we have a big database of very informative comments. We've solicited and are obtaining significant international input, which is very important to our process. I want to emphasize that our chairman and the commission approach these hearings with a completely open mind. We're very open to learning what we hear from these hearings. We're getting thoughtful analysis and suggestions from all quarters, from experts with wide-ranging perspectives about what's right about our policies and what we can do better. Like the 1995 hearings, we expect these hearings to help target the Commission's enforcement and policy for years to come. I very much encourage you to attend if you can. If you can't, stream them. And if you can't do that, the transcripts are online and there will be recordings. I'm sure you will find these hearings informative and hopefully provocative, and we welcome your input and your feedback.
Well, indeed, the FTC had not disappeared. I'm completely convinced, and is doing great work. I did have a couple of questions, however, on something that you mentioned, but I don't know whether you actually meant this. You said that the previous hearing in 1995 was quite important to inform the policy, the competition policy with respect to innovation, with respect to, and I certainly agree with that. But when you presented the current initiative, the current hearings, you said that it was to inform your priorities and your enforcement. So my question is, okay, let's assume, just assume for a second, that the hearing convinces the FTC that maybe the consumer standard is a bit narrow and we should extend it. What is the degree of freedom that the FTC has to change the interpretation of the law? In other words, is the only thing that we can expect from the hearing is a nice report on the fact that we should go in this and that direction, but not much in terms of enforcement? Or does the open mind that you have mentioned include the fact that maybe it would try new interpretations of the law?
Thanks. That's a great and key question, Fred. Let me try. There are things we can do and things we can't do. The U.S. antitrust law is governed by a set of statutes as interpreted by our courts, and they define the boundaries of what can be done in antitrust enforcement. Alas, we cannot interpret and implement them just as we would like, necessarily. But that's a good thing. The limit on what we could do, I would say, is if we were to, after absorbing all of the hearings and maybe some new learning and thinking, just hypothetically, if we were then to, after evaluating a merger, go into court and say, Your Honor, having carefully considered this, we think this merger is neutral for competition, but it's going to have a bad effect on a lot of small businesses. And it's going to result in closing some factories that are going to put hundreds of people out of work. And it might lead to diminishing the privacy of some of the customers of this company. And moreover, they're going to pollute this beautiful lake. I'm afraid that that judge would throw us out of court in a hurry because those considerations are simply not cognizable under Section 7 of the Clayton Act. However, that doesn't mean there's nothing we can do. And I want to give a historical example. And it's pretty clear, I think, as you all know, U.S. antitrust law has, in fact, evolved tremendously over the last decades from the way it was understood from the 1890 through the 1960s. And that happened because there was a great deal of new learning of academic research and publishing, new thought, the role of economics, for example. And this learning made its way into the courts through advocacy and publications and was absorbed by judges and later advocated by the agencies, for example, by Bill Baxter in the 80s. And that led to major changes in U.S. antitrust policy and enforcement. So vertical restraints that were previously per se illegal became analyzed under the rule of reason. Dynamic efficiencies were taken into consideration in mergers. And there was a whole revolution, if you will, of antitrust enforcement without changing one word of the Sherman or Clayton Act. So I think there's a lot of scope to incorporate new learning in the very flexible structure of the U.S. antitrust laws.
Very good. Any questions on that? I mean, maybe you have a reaction. I mean, you said that it's not on the hearings, but it's on the due process that you're working on in the ICN. You heard what Roger said, hopeless. Just one country can block everything you do. I mean, is that really useful to do this work?
I should let Roger clarify because that's not what he said. The convergence and progress in the competition field is done through a process of soft law. You know well from chairing the WTO group that we didn't make a lot of progress in formulating hard law. And soft law is made by complementary initiatives. And what's going on in the ICN and what we're supporting in the OECD and what Roger and the Antitrust Division are leading through the MFP are entirely complementary. And the FTC has been working very closely with our colleagues in the DOJ in the formulation and discussion of the MFP principles. In the ICN, it is a consensus model, but we've been able to achieve an amazing amount through that model. And you can go on the website, or you probably know that despite vast differences in laws, cultures, developments, and priorities, we've been able to articulate consensus best practice standards for everything from the definition of dominance to merger review procedures. And we thought this due process area might be impossible to find enough common ground, but there you will find just that on important principles of transparency, procedural fairness, confidentiality, and checks and balances in the ICN guidance on investigative process that we intend to convert into recommended practices this ICN year.
Very good. Questions? Okay. Two questions about to the FTC. I think the microphone is coming to you.
My question is, does the US federal government sometimes tell the FTC that there is a class of enterprises or a class of deals that we don't want you to look into, given the larger national priorities? And if yes, how often does that do so?
The answer is no. They do not, and they would not. The FTC was created explicitly as an independent agency. Our commissioners are immune from removal without good cause, and good cause is not disagreeing with the White House. And if they were to purport to tell us what to do, we wouldn't have to listen to them.
But you wouldn't get any money next year.
Well, look, we do have congressional oversight. That's a little different question from, I think, from the government. I think you meant the executive branch. We are, of course, subject to congressional oversight, and that's a good thing. And Chairman Simons, as well as Assistant Attorney General Del Rahim, just sat in front of our oversight committee for a couple of hours, and they let us know what they think, and that's, we listen to all stakeholders.
My question was with reference to the law permitting such a direction being given or an exemption being given.
I'm sorry, the law of, I'm sorry.
The law permit the government to tell you not to touch a certain class of cases.
No, it doesn't.
No. I don't know.
Sorry, the White House can't call up and say, you don't touch this sector. Congress can pass, can exempt sectors from FTC regulation. In fact, the Federal Trade Commission Act exempts common carriers, for example, and some other classes.
Hi, Randy, thank you. I wanted to push you a little on Frederick's next to the last question, which was, suppose the FTC believes that during the hearings it really has learned something new and wants to push the law. And you gave an example, I think quite rightly, if you talk about will it be admissible, does the law go so far as to include pollution in competition? The answer is no. And then you gave a second example of you can absorb new learning in the Bill Baxter example. So what if after the hearings the FTC says, yes, we think Joe Stiglitz is right on this point, one point, that there is a monopoly power problem, or at least a market power problem that is big data problem that is not being caught by our usual traditional presumptions. And firms can have that power even if they don't have over 50% of the market. And firms can discriminate 100% and exploit consumers, getting back a huge amount of consumer surplus. It's in that area I wondered whether you think, if the hearings were convincing on that, could the Federal Trade Commission take those ideas into account to condemn practices that aren't now being condemned?
I think the answer to that is yes, because ultimately we are meeting a legal standard that is flexible. We have to convince a judge in a merger case that it's going to substantially lessen competition. And if there's a new theory that we haven't explored before or we didn't believe in before that we now do, we could argue that indeed this merger would lessen competition for a reason that we haven't advocated before. Or in a Section 1 case, it's usually a rule of reason weighing of net pro and competitive effects. And if we conclude that a practice has a negative effect that we didn't think much about before or are thinking differently about now, I think there'd be no barrier to going in and arguing that we now think this should be more heavily weighted on the scale.
Last question from, next to, okay, the last two questions, but very brief. Ioannis and Madame.
Following up on Eleanor's question, with regards to the concept of quality, because I think, we are also discussing, I think the OECD has been quite a lot of work there. What do you think are it's a discretion that competition authorities have to integrate maybe some broader considerations in the way they define quality? Because, if we think about there's some people that are vastly the view that privacy is an element of quality. The same thing about innovation. Innovation is obviously something we want to promote, but the direction of innovation is something that we have to interpret in a certain way according to the legal framework that we have and the interpretative guidance we have from the rest of the legal system. Is this something that you think the FTC... So it's not really bringing directly the pollution argument, but the pollution argument and the way the legal system is set as to reduce pollution is a factor that you take into account in interpreting the quality of the innovation effect. And I just wonder what your views would be on that.
That was a short question by Ioannis's definition.
Good question.
Right. There's a canard out there that the consumer welfare standard means you look at only price, and as I think you all are sophisticated to know, that's nonsense. And that's clear from our merger guidelines and the agency's practice for years. And quality is certainly a dimension of competition that is cognizable and that we look at. And that could encompass innovation, and it could encompass something like privacy. It's harder to quantify. It's harder to measure. Our economists are struggling with, if I can say, with how to translate these concerns into an objective criterion to present to a judge. But if it could be shown that companies competed on the basis of the privacy protections that they offered, and that was meaningful to consumers, and that a proposed merger would likely result in the diminution of consumers' utility on that dimension, I believe that could and would be argued and could be successful. And innovation we certainly look at already. So I would say yes to both of those.
Very last question.
Oh, thank you for your comments. I have a question about an efficient enforcer of the Sherman Act, for example, a private litigant who comes into court or a class action group of plaintiffs, and they bring an action for violation of antitrust laws. And the courts, there's a four-part test. They don't necessarily want efficient enforcers. There might be someone better to enforce, like the government. How do you feel about private litigants saying they're an efficient enforcer, they get treble damages? Are they helpful to the government, or is the trend not to have efficient enforcers something that you think is something that's going to be going forward? And maybe the claim shouldn't even be brought then.
Okay, so role of private litigation in the U.S. Well, it's always been a dual system here, and the vast majority of antitrust cases brought in the United States are private actions. And I believe that they are complementary. We in the government can't bring every case, and we in the FTC don't get damages for injured parties. That's a role that private plaintiffs fill, and their cases help shape the law. In terms of efficiency, there's a debate about the efficiency of some aspects of our litigation system with contingency fees and discovery and treble damages and so on. But on the whole, I mean, private litigants have been, litigation system has been referred to as private attorneys general, and I think they're an important complementary part of the U.S. enforcement system.
Can I just echo, can I have a quick echo to Randy's comment? I totally agree with what he said. The other thing to really note about private litigation is that because the United States antitrust regime is essentially a common law process, it's incredibly important to have sufficient body of case law that actually can develop the law in a sort of meaningful way, robust way. And so, for example, this year, probably the most important antitrust case before the U.S. Supreme Court is Apple versus Pepper, right? That's a private litigant case, and that will be, you know, very significant in terms of clarifying the law on issues related to that. Makin Delrahim has decided to actively support private litigation by filing amicus briefs in a whole host of private litigation cases because he thinks that there are really important policy issues that are embedded in some of these privacy cases, private cases.
Well, thank you very much for this. Thank you, Randy. And just one piece of advice, if I may, to the FTC. You did say that you were going to Pakistan in a few months. No, not you personally, but the FTC was sending a team. I think that you should send a reinforced team with medics and a lot of medical equipment, because as far as I can tell, the Competition Authority of Pakistan is in a coma, or maybe a deep coma. But Joseph Wilson is going to talk to us about that. Yeah, sure.
I'd like to thank Professor Fox, Concurrence, for inviting me and for giving me this opportunity to be at the Enforcers Roundtable, even though I have ceased to be an enforcer for over 2 years. But nonetheless, I'm grateful. As we speak, the Competition Commission is defunct, and there is no member officially appointed. So what I can do, I can speak as an observer what should be under the radar of the Commission, and before doing that, I would put the Commission under the radar first. So to give a brief background, competition law, Pakistan adopted competition law in 2007. This was a new competition law on modern principles. We had competition law since 1970 in the form of Monopolies and MRTPO, Monopolies and Restrictive Trade Practices Ordinance of 1970. The focus of that was more on preventing concentration in the hands of few, but with the new regime, which was modeled on European Union law, we had this competition ordinance in 2007, which gets permanency in 2010 in the form of Competition Act 2010. The basic provisions, it has legislation, abuse of dominance, prohibiting abuse of dominance, and prohibited agreements. These two substantive provisions makes what is antitrust and basic trust. And then we had deceptive marketing, which is more of a consumer protection. And an efficient merger control regime based on notification thresholds based on size of parties and size of transaction. It's almost 10 years, so Commission at 10, the number of cases we have concluded in abuse of dominance is 16, prohibited agreements 21, and deceptive marketing practices is 32. If we look at the cases concluded, you would notice that in the first 4 years, the blue and red is the main antitrust. The focus is on abuse of dominance and on the
Just take the microphone in your hand.
Right.
That'll be easier for you.
Okay. In the first 4 or 5 years, it's red and blue, which shows that the main antitrust focus is there, abuse of dominance and prohibited agreements. And in the last 4 or 5 years, you would see that the green shade, which is deceptive marketing practices, is taking more precedence. And what I believe is if the Commission is not producing red and blue, it is losing its character of somewhat of a typical antitrust competition agency. And by saying this, I didn't mean to offend my friends at FTC who don't do criminalization, of cartelization. So that's not there. If you go further, look at the cases which were proactive, which were initiated by the Commission vis-a-vis, which were complaint-driven. The red shows the proactive action, the initiative taken by the Commission itself. And you would also notice that over a period, it declined after 4 or 5 years. The spirit of being a gung-ho was not there in the last 4 or 5 years. And this is, you can see in all the cases, in Section 3 cases, Section 4 cases, and Section 5, Section 10 cases as well. I had not talked about mergers, and that doesn't mean that merger is not important. In fact, what should be under the radar of the Commission is its merger control regime. To prove that point is the acquisition of Jade E-Services Pakistan, which is an online platform by Alibaba of Singapore Holding, although it's a Chinese company, but through its Singapore holding, it purchased this company. The analysis done by the Commission was quite simplistic. Relevant market, online marketplace platform, geographic market, whole of Pakistan. Analysis, the way it's done in a conventional brick and mortar enterprise, is market share of an acquirer, which was whenever a new entrant is coming, it's normally 0. Market share of the target, you take that as an X. And if you combine that, 0 plus X is X and delta is 0. Therefore, there's no strengthening or creating of dominant market. Therefore, the merger is allowed. Now, I think this merger regime need to be reviewed because this worked perfectly well when the businesses are not online. When businesses are done online, the geographic boundaries are broken. They cross the barriers, and there needs to be taken into consideration. So the issues with the review is online marketplace platforms are not constrained by national boundaries. Section 2K of the Competition Act defines relevant market as means the market which shall be determined by the Commission. So what that means, and arguably to me, is that the Commission is not bound to define the geographic market as just within the boundaries of Pakistan. It can go beyond, and we have seen cases where the merger regimes have taken cognizance of worldwide in order to have a merger threshold, worldwide turnover. No analysis of the impact of acquisition on the buyers and sellers on this platform. So when you're selling a platform, it's not that commodity alone, you are also selling the people who are trading on that platform. So that needs to be reviewed when you're looking at online platform, and that was not done at all. potential abuse of dominance by Alibaba once it comes in. It's not just a zero entrant and it's just taking an entity. It has a whole gigantic network behind it, which it will attach to the company there, and through that, it has the potential to wipe out local online marketplaces, kill innovation, and new upstarts. And the important thing is that acquisition of Daraz.pk by Alibaba is a necessary piece of puzzle for Alibaba to create global dominance. Now, that's something which the Commission does not take into account. I think as a global citizen in a globalized world where everything is constantly interdependent and is interconnected, this needs to be reviewed, that we are not becoming a party to giving global dominance to any entity. It's just like an effects doctrine. When you can take cognizance because the effect is coming in, it's the reverse side of that, the effect going out. Your action is producing an effect which is creating a global dominance, and that needs to be catered. So Pakistan is in a very fortunate position in a way that it gives the power to the Commission to review the act. Section 29 says the Commission shall promote competition through advocacy and by reviewing policy frameworks for fostering competition and making suitable recommendations for amendment to this act. This power means that the Commission does not need to wait for the government to constitute any review committee or to look into the law. The Commission can take cognizance and can go on and look into the actions itself. It's just like the FTC hearings. They are in a position to do that. So the concluding remarks for today is that it's time for the Commission to engage in self-assessment to see that the red and blue should be there every year and competition priorities, and to undertake a thorough study of revising its merger control regime to take account of online dynamics of businesses.
Thank you very much. Well, I tend to disagree with your last statement that it's time for the Commission to review, to propose changes in the law. And the reason for that is it got 3 stars from the GCR. So everything is fine. Okay. Now, it does raise a question about how do you get 3 stars from the GCR when you have, as you have explained, a system which is far from effective. But since we're not talking about GCR here, we will not get the answer to this. But I did have a serious question, which is, with Janos, we sat on a PhD examination of a student who is comparing Indian competition law and Pakistani competition law, not only from the point of view of the law, but also from the point of view of its success. And basically, the argument was that one of the differences, which may or may not be of importance, but I would like you to tell us, is that there were really extensive consultation in the case of India, and in a sense, the competition, after the MRTP Act, when they changed the law, that there was kind of maybe not a consensus, but at least a lot of consultation, and therefore a lot of people got a stake into the new law. Whereas in Pakistan, it was more imposed from the top without much consultation and without much discussion about the usefulness, the value of having a competition law. Could that explain some of the difficulties that you have talked about?
No, I don't agree with that analysis.
Okay.
If you look at the first 4 or 5 years, if it's been thrusted upon from top to bottom, it shouldn't have been that efficient in the first place. The efficiency declined towards the end of the last 4 or 5 years. So what is happening is it's the quality of appointments, the people who are working there, whether they have a relevant skill set. Without naming, we have, I know that there was a commissioner who was appointed who never heard of the agency, the Competition Commission of Pakistan. He was appointed because he was a friend of the Prime Minister. And he's a geologist, he was a geologist by profession. So with those kind of appointments, political appointments, you're bound to lose the momentum.
So it's more institutional design issues than anything else. Sic transit gloria, you can go from, fairly good, effective competition authority to a quasi-dead body. But I understand that new commissioners are going to be appointed.
Yes.
Prime Minister has other
The
friends.
new government is in the process of appointing new commissioners.
Okay, well, let's hope that the new commissioners will be up to the task. Are there any questions or comments outside of what we've talked about? But to the panelist member, we have 2 minutes, so there can be one short question. Mr. Horta from UNCTAD.
Merci, Fred. My name is Pierre Horna. For those that don't know me, I work for the UNCTAD Secretariat, and I would like to congratulate the panelists today. I would like to have a comment regarding the presentation of Mr. Alford regarding this issue of the multilateral framework of procedural fairness. I don't know if you are aware, but we have in the UNCTAD Secretariat set up a discussion group on international cooperation a couple of years ago, where your colleagues are actually part of it together with FTC as well. And we are precisely discussing some of the areas where you can have some convergence between competition authorities. We have recently entered into the second year of discussions, and we value very much the importance of these initiatives that you have presented today, which it seems to be very active. At the same time, we think that international law, as you mentioned, it's actually very important from both sides, international soft law, international hard law. I happen to be here International Law Week at the UN Secretariat, where we have different types of commissions talking about how international law is being shaped, and the report of one of these areas, which is the international trade law, talks about precisely what you referred today on procedural fairness as well. So my point here is that it is true that there has been quite a lot of work on different organizations, and I would like just to refer to the fact that the importance of having a wider membership of the United Nations will allow also member states to look at this variety of issues on a comprehensive way for a number of reasons that you mentioned earlier, but also because there's an area in which we also need to have not even consensus building, but also the way of convergence is going towards the issue of international cooperation as a whole. We are aware and we are mindful about the challenges, and actually thanks to your colleagues, we have been able to come up and gather all the information from the ICN and OECD secretariats in the last 1 year and a half. So we would like to encourage perhaps you and your colleagues to also find avenues for a greater convergence of a UN membership, which is at the service of your government and many other member states around the world. Thank you.
Yeah, so thank you for those comments, and I failed to mention UNCTAD, but obviously it's something that we are very actively involved in. We attend all of the UNCTAD meetings. We follow the initiative that you mentioned. My sense is that it is not addressing due process in the same way. It's focusing on other priorities more than due process. Obviously, it's different in the context of government-to-government discussions, at government-to-government negotiations. What we've been focusing on, both at the ICN and in most respects at the OECD, although some recommendations can go all the way up to the government, and then also with the MFP, is agency-to-agency cooperation. So it's a little bit of a different arrangement than that, but obviously we do follow it closely, and we're actively involved in that as well. So thank you for that comment.
Thank you very much. It's cocktail time. Not quite. We must take the time to thank our enforcers for having given very frank and very precise answers to the questions that we asked them, and for having raised a number of rather interesting questions. So thank you very much to all of you. And now I give the floor to Eleanor and Harry for the very, very last.
I read one article that said that, and I didn't know what that meant. Okay. Okay.
They're opening on their watches.
Huh?
I think you should leave some of your watches.
Okay, Harry and I are just going to give you a couple of closing minutes after this additional very interesting panel. So Harry,
Yes.
What did you think were the most important takeaways from the whole conference today? You can ask me the same thing afterwards.
Yeah, so that's a great question that you asked me first. So the first thing that struck me is how often we're talking about consumer welfare as the goal of antitrust. I say so often because I don't know which conference I'm at that I'm talking about it. Let's see, last week it was someplace, and anyway.
Last week was Portugal for
Last
you.
week was Portugal, right, and next week it's going to be Cambridge. It is interesting, and Dennis Davis said in connection with this, so exactly what do you mean by consumer welfare? It's one of those great two-word lines. It's, I tend to think of it as more rhetorics than economics, because, you know, when Bob Bork wrote it, he didn't really mean consumers. He meant overall economic welfare, growing the pie. So people use this differently, and we're still talking about the goals of antitrust. And when did we pass the statute? You'd think we'd know it now, but this is the perennial topic and very important. So I think it's still motivating people a lot. So you can all think about how that term is being used and how you would use it, and whether it both justifies intervention or, more importantly, whether it justifies not intervening because you don't find any impact on consumer welfare. So that was the first thing. Now over to you, because we only have a New York minute.
Oh, right.
I have other things on my list.
All right, so I'm going to respond to you.
Okay.
And then you can go back. Okay. I wanted to say this about the issue you raised on consumer welfare. I think raising that issue actually undercuts the project to be more sensitive to developing countries' needs for the following reason that was expressed here by about 5 or 6 different people, that if we think only about consumer welfare, we are usually having a paradigm of non-interference unless there's harm to consumers. And it can be innovation harm. I mean, it doesn't have to be the narrowest use. But I think you've seen from a number of our participants from developing countries that they are saying that the vision has to be wider, it has to be more dynamic, they have to create markets where none exist, they have to, in the process, try to get rid of the cronyism and barriers that were put up by vested interests. They have to enable more plurality of people engaging in the economic process. And so if you are saying this, which many people are saying today in the United States, protect the consumer welfare standard, or else you're going to go down a deep or slippery slope in which you're degrading antitrust. That leaves out this middle in which the developing countries are trying to make their markets more robust, and the idea is excluded by being bad antitrust and bad for markets and bad for society. So go back to you.
Right. So that fits in with it may be a reason to act, but it's not clear to me that it is a reason not to act. So there may be broader
that's right.
things.
Yeah.
And that ties into the second thing on my list, which is is there one size fits all? Is convergence the be all, or is there not one size fits all? And I think if there's anything that comes out, this being our 5th conference, is that one size may fit all if you're in a one-size place. But if you're looking around the world, the institutions are so different, the problems are different, the strength of market institutions, of legal institutions, and of the goals are so different that you really can't take that position. And I think it's wrong, and this ties into what you said, to condemn the efforts of developing countries or other countries, or maybe New York State if it wants to pass a different Donnelly Act. I'm looking at Bob Hubbard, to try different things with having different views.
Right. So great, Harry. I want to play off that also. That I want to refer to Dennis Davis's remarks on the BRICS panel. So the question was asked to him. is there going to be one standard, or are there going to be two standards? And Dennis said the following. First of all, that we need a platform that is not the hegemonic platform. Maybe that sounds not neutral, but it's meant to be neutral. It means we need a platform that's not the tried and true platform of the developed world. For developing countries to start thinking from their roots up and their cultures what they need to protect themselves against market power. And it might be a diversity, it might be a plurality. So here's where the BRICS project comes in. The BRICS project being not only for the BRICS, as was said. I mean, it would be initiated by the BRICS, but a research project. It would be a platform to think, expand your mind, think what countries need, and countries can draw from it. There's not ever going to be, as Dennis said, not ever going to be one standard. But if countries that are, for example, fit into this broad area of characteristics of developing countries, they can have a neutral forum for thinking about new ideas that aren't path dependent. Trying to make their markets work. I'm still on a point of trying to make their markets work. I'm not at a point about how to save our planet, though I'd love to save our planet from pollution. I mean, from a lot of other things, but pollution.
Yeah, I didn't know where that was going exactly,
Okay,
but
yeah.
I'm going to follow Dennis's view that we've replaced that word with, what did he replace Trump with? I can't remember. Over something, well, Dennis is gone.
Override,
yeah, something
that's
else,
right.
okay.
Yeah.
So we may be past our minute. I want to ask a last question. Well, maybe I shouldn't say it's the last one, because you may
No,
have
you
a
have
retort.
the last one, go
Oh,
ahead.
okay. Wait, I had the first one.
I might make the last
So
sentence.
one of the things that struck me, is Roger here, or has he left? Okay. So the idea that you have a project to which no one disagrees struck me as either it's not true or not worth doing. I couldn't quite figure out which. Well, you know, he said everyone loves this due process. Who wouldn't like due process? But
Everyone agrees on the norms that we've identified, but there's strong debate about the reviewing.
Whether they have to stick to them and whether
Well,
they feel they
yeah,
have to stick to them.
Well, so this is an ongoing question, but I think as we're thinking about due process and rule of law, certainly we in the United States can continue to think about our own commitment. And the CFIUS process actually is one that I worry about in the United States in terms of a secret process in which the competition people actually don't participate, and which doesn't conform to the kind of process that we're used to. So that's mine.
Right, so
My last word.
I will then just
You
add
get
one sentence for the end, which is to say, ending at the beginning, Finnegan's Wake, that Joe Stiglitz said talked at the outset about new forms of power. And I did say when I introduced him, which always intrigued me, he was fired from the World Bank because he was so angry at the IMF for not listening to developing countries and not having a view that their markets might be different and they might need something different from the developed countries. And so just carrying that theme to the end, I think we've made some progress here today. I've heard a lot of really great contributions from the podium and questions and comments from you too, which really do try to dig more deeply into the platforms that various developing countries and countries in various states of development have, and what they need to make their markets more robust. And sometimes that wasn't along a traditional line of what we know about very traditional antitrust law. So we are trying to listen to developing countries. Thank you.
Thank you all.
Drinks now, are there not? Yes. Come join us for a drink and a little more conversation.